You may not agree with burning the Quran or any religious text as some form of protest, but that doesn't make it a crime. We've had MPs in Parliament calling for the prohibition of burning such texts, particularly with regard to the Abrahamic religions. But again, it is not a crime. We've not had blasphemy laws in the UK for nearly 20 years now. However, we did have somebody, as you'll recall, prosecuted for burning the Quran, and it was originally charged as causing harassment, alarm or distress to the institution of Islam. But that was then amended to a straightforward public order offence, but aggravated by race or religion. I am pleased to tell you, whilst I stress that I don't agree with the burning of the Quran or any religious text, but I am pleased to say that the appeal of Hamit Coskun's conviction for exactly this has been overturned by the Crown Court. And I'm going to go through some of the commentary by the court in that case in this video. And a few other comments on it as well. But it is also thanks to Free Speech Union. If you're not a member of Free Speech Union, I suggest you join. This is not a sponsored video. They've not asked me to do it. They don't know I'm doing it. I am a gold member. I suggest that you join, and I wholeheartedly support them for doing so. And so they have supported him in this appeal. And in Robert Jenrick's comments here, which is precisely what I've just said, you may find the burning of the Quran offensive, but that doesn't mean it's a crime. And he attended Southwark Crown Court with Hamit Coskun for this appeal. Now, you might also recall that I did a video to launch my Off the Record channel, which I'll link below. Please do go and subscribe to it. Thank you all so much for subscribing. There's over 113, I think, thousand of you now. I did this video to launch that channel to give you my general views and raw views on all of these things, and one of which was because of when I launched it was at the time about this case and my thoughts in general about that. Now, I made clear that I don't agree with burning any religious text, but that it is not a crime. So just to remind you, this was 4 months ago now, just to remind you of what I said very, very briefly, I'll play it for you here, and I'll link this full video below. Now, we also have the recent guy burning the Quran, who has now been convicted of a public order offence. Do I agree with burning the Quran? Of course not. Well, I hope it's obvious that I don't agree with that. It may not have been obvious, I don't know, but off the record here, I don't agree with that. I do think that is a horrible thing to do. But should it be criminalised? No, I don't think it should, because if that is an absolutely bold statement for somebody to make, it's their place to make it. And that's entirely the point here, and that is what will feed into the commentary of the Crown Court in the appeal comments, which I'll read out some of in a moment. And it's all based on the right to protest and the freedom of expression. Now, as I mentioned, I can actually pull up for you the original charge was written thusly. It was originally written as the particulars of this offence charged were that he did with intent to cause against the religious institute of Islam harassment, alarm or distress by displaying some writing, sign or other visible representation that was threatening, abusive or insulting, thereby causing another person harassment, alarm, distress, etc. Now, that was amended because there was criticism that it couldn't be harassment, alarm or distress against the religious institution of Islam. So that was amended to be I say straightforward, fairly technical public order offence, but nonetheless, it was amended. Now, here are the Crown Court comments on that, and there's a letter from Robert Jenrick, which I'll come back to in a minute, but here is the Crown Court commentary on that. If I switch up to highlights, there are certain bits that I've highlighted that I can talk to you about here. As I mentioned, this was a Section 5 public order offence as charged. Now, I've mentioned in previous videos that this should not have been a Section 5 public order offence. There is no offence of blasphemy and burning your own property, save where it might amount to arson, which is either intentional or reckless endangerment of life, which makes even burning your own property an offence of arson. Burning your own property is not a crime. Burning your own things is not a crime, and there is no specific offence of blasphemy in our law. That is what the Crown Court here. And just to explain this a little bit, when you are convicted in the Magistrates Court, you have an automatic right of appeal to the Crown Court. And when you appeal to the Crown Court, you get a judge and 2 justices of the peace. So you don't get a jury in an appeal to the Crown Court. And I can show you that here It was before Mr. Justice Benathan, Miss Guest JP, and Mr. Graves JP. On another note, one thing I really can't quite believe is how bad phone reception and even mobile data reception is around and about the UK, even in and around near a city. I live in a city and I still have trouble here. And yet, when I went abroad, or when my son went abroad, we each had problems until we used Saley, who provide seamless data access to the internet with an eSIM, so you don't wait for a physical card to turn up. You install it on your phone via an app, and then you buy a plan for the country of destination when you arrive, and it just works. Why can't the UK be like that when Saley make this possible for hundreds of other countries when you're traveling around the world? You don't even need a SIM card. You just download the app, you install it as an eSIM. When you're ready to travel, then you buy a package. Make sure you use my code BlackBeltBarrister because that will give you 15% off at the checkout. And then it will just activate seamlessly when you arrive and you get seamless access to the internet. It even gives you the security features that you get with NordVPN, which include a virtual location, an ad blocker, and checking for malicious websites and malicious downloads. Some of my viewers now use this as their regular data service in other countries because the other services are so bad or so expensive there. And so they use Saley as their normal data plan. So I will certainly be using it when I travel in future, but make sure you use the code BlackBeltBarrister because that will give you 15% off any plan you choose to buy. So thank you to Saley for sponsoring this video, but also providing a service that everybody really needs, even in the UK. So let's take a look at this so that you can understand what the court has decided here in overturning this conviction. Now, as the court pointed out here, whilst it was charged as an offence under Section 5 of the Public Order Act, it turns on its own facts of each particular case. However, it said there are some important matters central to the decision. They say that they are not seeking to create new law, and they do not do so, but what follows is a clear and well-established proposition in the law of England and Wales. So it talks here, it says there is no offence of blasphemy in our law. Burning a Quran may be an act that many Muslims find desperately upsetting and offensive. The criminal law, however, is not a mechanism that seeks to avoid people being upset, even grievously upset. The right to freedom of expression, if it is a right worth having, must include the right to express views that offend, shock, or disturb. And that's a really key point here, because I will join with anybody that says that this is an awful act and it will upset people, it will offend people. But at the same time, it was obviously done as an extreme form of protest. But that's what it was. As you will see through this judgment, it was done as a form of protest. So nobody, just to be clear, should confuse my explanation here of this judgment with me agreeing that it's a nice thing to do. I don't think that, but I'm explaining the law nonetheless. So the judge said here, we live in a liberal democracy. One of the precious rights that affords us is to express our own views and read, hear, and consider ideas without the state intervening to stop us doing so. The price we pay for that is having to allow others to exercise the same rights, even if that upsets, offends, or shocks us. I've been through this many times in other videos. It's absolutely clear we have the right to offend and shock and disturb other people. There are limits, but it has to be grievous limits that it passes. Court went on here. The criminal courts will interfere to protect people, which is a distinct legal difference. A person who acts so as to cause harassment, alarm, or distress to another may commit an offence. These propositions have been articulated in numerous decisions of the appellate courts, both domestic and the European Court of Human Rights, and so on. So there's lots of cases here that have looked at that. However, they must all be balanced against the right to the freedom of expression, which the court addresses here. Article 10 of the Convention. Everyone has the right to the freedom of expression. This right shall include the freedom to hold opinions and receive and impart information and ideas without interference by public authority, regardless of frontiers. This article should not prevent states from requiring the license of broadcasting, etc. Furthermore, the court talks of the Section 5 offence, the mental element of which is contained within Section 6, which is where a person is guilty of an offence under Section 5 only if he intends his behaviour to be or is aware that it may be disorderly. Now, I'm not reading the whole of this document out. You can find it online. But at paragraph 15, the court said, we note in passing that demonstrating hostility to a racial or religious group is not by itself an offence. It is only when an accused is found to have committed another offence that they are held to have committed a yet more serious crime by reason of their expressed prejudice. Just to explain that a little bit more in simpler terms. simply demonstrating hostility to someone of a racial or religious group is not by itself an offense. So being hostile by itself is not an offense. Only when someone is found to have committed an offense. So let's say it's criminal damage. Let's say it's assault. If either of those offenses or any offense is found to have been committed and as motivated, at least in part, by some kind of hostility in relation to racial or religious group or sexual orientation or anything else, then it can be deemed to be a hate crime, which is a more serious version of the same offense. And so that's what the court is making absolutely clear here. The court went through and summarized the facts and then came on to discussion and decision. So again, if you want to read this in full, it is available online. I'll try to remember to link it below. But the court then said the questions we may have to answer in this appeal are as follows. Now, there's a number of questions. I'll read them all out for completeness, but as you'll find, it was only really necessary to deal with one of them. But I'll read them out nonetheless, because I think it is important to know and to understand what the court's thinking process was here. The court set out what questions needed to be answered to address this appeal. 1. Has the prosecution made us sure, the criminal standard of proof, that the defendant used threatening or abusive words or behaviour or disorderly behaviour? If the answer is no, then the appeal must be allowed. Secondly, has the prosecution made us sure that the defendant did so in the hearing or sight of a person likely to be caused harassment, alarm, or distress thereby? Has the prosecution made us sure the defendant intended his behaviour to be or was aware that it may be disorderly? 4. Has the defendant persuaded us that it is more likely than not that he had no reason to believe that there was any person within hearing or sight or was likely to be caused harassment, alarm, or distress, or that his conduct was reasonable? Those are the defences, and that's why the standard of proof is different, more likely than not being on the balance of probabilities, which is the defendant's standard of proof. So anything that the prosecution has to prove, they have to do so beyond a reasonable doubt. Also, the modern phrasing is that the court is sure, and that includes the jury, if there is one, that they are sure that something happened or didn't happen, and so on. Whereas the defendant's standard of proof is just on the balance of probabilities, more likely than not. So the defendant will never have to prove something to the criminal standard. It's only the state that has to prove it against the defendant to the criminal standard. So paragraph 4 here, these questions relate to the defences. Paragraph 5, or question 5. Are we sure the defendant demonstrated towards the victim of the offence hostility based on the victim's membership or presumed by the defendant membership of a racial or religious group, or that the offence is motivated wholly or partly by hostility towards members of a racial group? So addressing the first question, the court talking about whether it was disorderly and whether we are sure that it was likely to cause harassment, alarm, or distress, the court said that this was clearly a political speech or conduct. Insulting conduct is not sufficient, and we should be careful not to read down the words we're considering. The court said, first, the defendant's conduct was not aimed at a person. While such a generalised protest might amount to an offence under Section 5, it is less likely to do so than one where the conduct or words are directed at a person or people. So it was a standalone protest, in other words. Second, the court said the location was outside the Turkish consulate, the offices of foreign nations. They are recognised locations for political protests. A protest outside someone's home or place of worship may well create an anticipation that those who witness it may be vulnerable, etc. Third, the defendant was by himself. There were one or two other people around, but the only person involved in the protesting activity was him. As a matter of common sense, on many occasions a crowd might be intimidating far more easily than one by himself. Fourth, it was daylight. Any passerby could clearly see that he was stood by himself, empty-handed, save for the book that he burned. Fifth, his protest was short duration, perhaps 2 or 3 minutes. The longer the potentially distressing protest occurs, the greater the likelihood that someone will be harassed, alarmed, or distressed by it. Sixth, the reaction of people who were present is not determinative. The Section 5 offence criminalises the effect of conduct that is likely, not that which actually transpires. Yet the court said the reactions of those who witnessed the event in real time can be relevant to a court, etc. There is no sense, the court said, that any of the passers-by or spectators feel sufficiently alarmed to hurry away or even to cross the road. They see a man by himself on a fairly empty pavement who shouts and sets fire to a book. At the risk of repetition, their casual reaction to the defendant's conduct are not determinative, but they are telling. So there wasn't much of a reaction. Seventh, in our view, the actions of Kadir and the delivery cyclist do not assist the prosecution's case for a number of reasons. We're concerned with the likely, not actual. So it's what was likely, not what actually happened. You recall that he was attacked in response and the man ran off and got a knife and came back to attack him. Both men may very well have felt insulted, but that is no longer a basis for the Section 5 offence. So insulting is no longer part of Section 5. Kedru may well have grown very angry, as his threats to kill, then procuring a knife before attacking him would tend to suggest, but being angry is not the same as being harassed, alarmed, or distressed. Further, as articulated in case law, the court should be wary of allowing the criminal reaction of one person to make a criminal of another for exercising the right to free speech. That is really worth repeating here, because this is probably one of the points that could be and should be cited and quoted when anyone else is looking to defend such a case. So repeat for emphasis, the courts should be wary of allowing the criminal reaction of one person to make a criminal of another for exercising the right to free speech. Putting it another way, someone exercising their free speech, causing someone to get angry and then attacking them for it, doesn't make the person exercising free speech a criminal for saying those words. It follows from our consideration of the evidence that the prosecution have not succeeded in making us sure either that the defendant's conduct can properly be found to be disorderly, or that it was within the hearing or sight of a person likely to be caused harassment, alarm, or distress thereby. The court said we therefore do not need to consider the latter issues upon which we've been addressed, and we must allow this appeal. And then it talks about the alternative charge. In the court below, the alternative charge of Section 5 in its unaggravated form was adjourned sine die. Mr. McGee very properly reassured the court and the defence that if we allowed this appeal, that there was no prospect of that charge being revived, and we would add that to do so would, in our view, be an obvious abuse of process in any event. So, in other words, they were saying that they were not going to pursue the lesser charge, the unaggravated version of the offence, because the offence itself fell away. So it mattered not that it was an unaggravated form of the same offence. So, in short, the court is saying that just because someone got angry and attacked him for what he was doing and saying doesn't make him a criminal for exercising free speech. Now, let me just say that you can agree with this decision in support of free speech at the same time as disagreeing with the action. That is sort of the point of a protest. They are protesting against something. So you could agree with the protest, but you can disagree with the way they protest, and you can agree with the decision, but disagree with what the decision was about, fundamentally, the burning of the Quran. Now, many people will find that offensive. A great many people who agree with this decision and support of free speech will disagree with the notion of burning a religious text of any kind. But a blasphemy law, it should not. And as many did criticise, this was somewhat a blasphemy law by the back door. It was even criticised by senior leading King's Counsel that the original charge itself was defective, because one cannot harass, alarm and distress an institution of a religious group. It needed to be targeted at a specific person, or likely that someone would be caused harassment, alarm, or distress. But now we come to Robert Jenrick's response to this with his letter, because his letter here said, Britain does not criminalise blasphemy. There must be accountability for the catalogue of failure in the Coskun case, he says. It must never be repeated. And this is a letter to the DPP, to Stephen Parkinson, King's Counsel, the Director of Public Prosecutions. And if I open this in a new tab, I can zoom in. It says, today the Crown Courts allowed Mr. Koskun's appeal. The court could not have been clearer. There is no offence of blasphemy in our law. Burning a Quran may be an act that many Muslims find desperately upsetting, etc. That's the bit that I read out from the appeal. Robert Jenrick then says, I was angered by the initial charge, framed as causing harassment against the religious institution of Islam. That was a legal absurdity. The Public Order Act protects people, not beliefs or institutions. Parliament abolished blasphemy in 2008. It is not for prosecutors to recreate it by novel drafting or for courts to police hurt feelings. But importantly, and here's a legal point here, because this is a Crown Court decision, it does not bind other courts. That is not to say that it's not persuasive on other courts. You can cite this judgment now, this appeal judgment of the Crown Court, but it is not binding on any other court. It is going to be persuasive, as these cases usually are, and that is why very often now you see these judgments and these comments and sentence remarks and such made public. It is in an attempt for clarity, so Firstly, the public can understand what's happened. Secondly, that it's more easily referenced in future cases so that we don't repeat the same things again and again, albeit every case turns on its own facts. And essentially, Robert Jenrick encourages them to pause and review any current or contemplated prosecutions in relation to such offences. And I would agree. I think any such offence like that, or of this sort of nature, or any kind of protest nature, should be viewed in the same way, save where they are obviously crossing criminal boundaries to criminal damage, attacking police, attacking buildings, attacking vehicles, and all of these sort of things. So those things are obviously criminal acts, but merely protesting, even if somebody finds it offensive, it is not an offence. And it's certainly not a blasphemy offence, because we don't have such a thing. So I hope you found that useful. There are other quite ridiculous stories that I can talk about. I will talk about that on my Off the Record channel, because a Scottish Reform counsellor has been reported to the police after saying that she was born and bred in Falkirk. I think that's ridiculous to begin with, but I'll talk about that in my Off the Record channel. So pop over there and subscribe there too, and thank you for watching.